Good morning, everybody. Thank you for waking up fairly early. For lawyers, it is. Normally, we get into the office at the crack of noon, just in time for an early lunch. Um, Today, we're going to be talking about updates in construction law, and I have the pleasure of presenting with David Weiland, my partner, whose bio is up, as well as my partner, Craig Tristao, whose bio is also up right now. For those who don't know, Coleman and Horowitt is a 21 lawyer um, litigation and transactions firm. We represent businesses and their owners, and since 1994, since our start as a law firm, that has been our focus. We have practice areas in business transactions, real estate transactions, estate planning, probate, uh, banking and finance, creditor rights, intellectual property, and litigation, which also includes a robust group of attorneys who have experience in construction litigation. David, Craig, Greg Norris, me, Fred Miney, Cheryl Noel, um, Sherry Flynn, and others in the firm all handle construction litigation. More can be found on our website at ch-law.com, but for today, you have us three. And why don't we go to the next slide and let's talk about what we're going to cover this morning. We're going to we have an hour and a half allotted, but we're going to try and get you out of here as quickly as possible because we know you always have better things to do than to sit around and chat with lawyers. But today we do have several areas where the legislature has been busy in 2020 to get new laws enacted for 2021. These are not all of them, but we will be covering COVID-19, new statutes regarding licensure with the CSLB, public works projects, housing and residential, worker classification, wage and hour, leave of absence, pay data, CEQA, and wildfire legislation. As Ali mentioned at the very beginning, if you have questions, we urge you to ask them. Please just put them in the chat feature as they come up. The speakers will have the ability to look at the chat button below. If there's a particular question on point, the speaker can either interrupt, and we can have a discussion at that point, or our hope is that we'll get through this material and then have questions at the very end instead of this being interactive. It's a little bit harder in person. It's easier to do an interactive program where you can just ask questions. When it's on Zoom, it's a little bit more difficult. So we're going to try questions at the end. And so why don't we start off with COVID-19, and I'll pass this off to Dave Weiland. Dave?
Good morning. As you all know, California is a very pro-labor state, and the new bills that were enacted dealing with COVID-19 are certainly no exception to that. They all provide additional benefits in one way or another for employees. And there were a number of those that were enacted. Some went into effect in 2020. Some are effective as of January 1 of this year. So in one way or another, all of the bills that I'm going to be discussing are already operational. The first one is AB 685. It was approved by the governor on September 17th, 2020. And this bill allows Cal OSHA to actually shut down your business if an inspector determines that your place of employment is a hazard due to COVID-19. And the way it shuts you down essentially is that Cal OSHA can prohibit employees from entering your building. It requires the employers to notify employees of potential COVID-19 exposure. It also requires companies whose employees are represented by unions to notify the designated union representative. And the notices must include a implementation plan for disinfecting the premises and a safety plan. All of these notices have to be kept for 3 years, and it relies on a definition, or excuse me, a definition of the term outbreak. And an outbreak is defined in the code elsewhere. But if your place of business does qualify as an outbreak of COVID-19, you're also required to notify local public health agencies of that fact. It also gives Cal OSHA the authority to label as serious the violation if there is a realistic possibility of death or serious physical harm. So this is a pretty all-encompassing bill with regard to protecting employees against COVID-19, and it stays in effect until January 1, 2023. The next bill I'd like to discuss is SB 1159. Now, if you recall, back in May of 2020, the governor issued an executive order that created a rebuttable presumption that an employee working from home and in the office, if they contracted COVID-19, there was a rebuttable presumption created that that employee got COVID-19 at work, regardless of what they were doing at home. That executive order has now been approved by the legislature in Senate Bill 1159, and it has become law. And by a rebuttable presumption, it means that the workers' compensation system, the appeals board, whatever, is going to automatically assume that if an employee becomes ill with COVID-19, they got it at work. Now, the employer can rebut that if you can prove that the employee was actually out partying some weekend and, you know, with their university alumni or whatever, and there was a super spreader event or something like that, and they actually got COVID-19 at that event. But that requires some evidence and proof on the part of the employer. And this bill applies to employers who have 5 or more employees. And it actually defines the term outbreak, which for employers of 100 or less, that means 4 employees that test positive. If you have more than 100 employees, it requires 4% of your workforce to test positive to qualify as an outbreak. It also qualifies as an outbreak if the place of employment is required to be closed by Cal OSHA. It also includes a provision that the employees must exhaust all of their sick leave, which means regular sick leave and emergency sick leave, before they can avail themselves of disability benefits. This law does not expire until January 1 of 2023. We are encouraging our employer clients to keep in close contact with their workers' compensation insurance carriers because some of those carriers have their own reporting requirements, and it's important to know what those are. And the bill also spells out the Cal OSHA notices verbatim that have been adopted and will be used by Cal OSHA for these COVID-19 purposes. The next bill I want to cover is AB 1867. This was a pretty short bill, however, it has a broad reach. It expands the scope of COVID-related sick leave benefits to certain food workers. It has a limited application to the construction industry, but given the way the courts broadly interpret these kinds of rules in California, it does have the possibility of affecting your businesses. This bill, however, expires on March 31st, 2021. So it has a very short lifespan. I now would like to cover some licensing bills that went into effect. The first one is SB 1189. There we go. This bill creates a new licensing classification. It's called a B2 license, and it targets contractors who do residential remodeling work, primarily of wood frame structures and residences, using 3 unrelated building trades. So it's similar to the B license, but it's limited just for contractors who are working on residences. It has some punitive provisions in it that include enhanced provisions for criminal sentences if a contractor takes advantage of someone who has a need for remodeling of their residence due to a natural disaster. And this really arises out of the recent fires in Northern California, where, following the fire, contractors descended on various communities and encouraged homeowners to utilize their services to remodel or repair their residences. There was a lot of abuse that occurred arising out of those fires. The bill limits the utility of the B2 license and does not allow the contractor with that license to modify any structural component of the building. In other words, if there's a bearing wall or a structural post or a beam or something like that, the B2 licensed contractor cannot modify that particular component. In addition, they cannot alter or extend electrical materials, plumbing systems, or anything related to the structural components of the residence. The next bill is Senate Bill 1474. This was approved by the governor on September 29th, 2020. And it changes the licensing requirements for entities where their license has expired. Under the prior law, a company had 90 days following expiration of their license or upon the resignation of their RME or RMO to apply for a new license. However, that application was not retroactive. So under the new law, it is retroactive, and it is retroactive to the date that the license expired. So this actually helps contractors. However, the application needs to be postmarked prior to the expiration of the 90 days. So that's important to keep in mind. And where this often comes up in our practice is contractors who change their operating entity. For example, if they change from a sole proprietorship to a LLC or to a corporation, you have to get a new license for the new entity. And a lot of contractors forget about that, and they just don't do it timely. Well, this does give you a 90-day window, and it would be retroactive to the date that your prior license expired. The next bill is AB 3075. This is primarily an information gathering bill. It requires, in addition to all the other information that you have to submit to the Secretary of State in your annual statements of information, that you now have to include a reference to any judgment issued by the Department of Labor Standards Enforcement, which is the labor commissioner, dealing with wages of any kind, either a single employee who got a judgment for unpaid wages or a prevailing wage violation or anything arising to the level of a judgment issued by the labor commissioner. It also allows local entities to enforce more stringent prevailing wage standards than the Department of Labor Standards Enforcement. That's not necessarily a big deal in the San Joaquin Valley, but if you're doing any work in the Bay Area or in Southern California, those entities in those locations will oftentimes have prevailing wage requirements that are more stringent than the labor commissioner might otherwise adopt. There are also oftentimes project agreements where the public agency has entered into an agreement with the local unions that may require additional wages or benefits or something above and beyond what might otherwise be required by the labor commissioner. So it's important to understand that in addition to the judgment information that has to be submitted with your annual statement of information, there are these other provisions that allow for higher wages to be paid by local or with local entities. The next bill is AB 2210. This bill is targeted specifically to contractors who do any work with trimming, removing, pruning trees. If you're on a construction site and you have some kind of tree work that needs to be done and you hire a subcontractor to do that work and they violate any OSHA standards, those violations can be classified as serious as long as the inspector deems reasonably that there's a risk of death or serious injury that could have resulted from the violation. Again, this is an expansion of Cal OSHA's scope of responsibility. The bill also extends the time for potential CSLB violations from 180 days to 18 months. So it's a much broader window for violations for any, or for discipline for any violations arising out of the work that's covered by this bill. The next bill is AB 2471. This bill modifies the home improvement provisions of the Business and Professions Code to extend from 3 days to 5 days the right to cancel a contract for anyone 65 years of age or older. It specifies the specific wording that must be in the contract. And if you do any home improvement work, you probably know that in Business and Professions Code section 7151, there is specified a number of specific provisions that have to be included in the contract with the property owner. This particular bill restates those and adds to it this change in the rescission right from 3 days to 5 days. So if you're not familiar with the requirements of what has to be in a home improvement contract, take a look at Business and Professions Code 7151 or call one of the partners at our office and we can certainly walk you through those provisions because they are very specific. And the Contractor State License Board frequently cites contractors for not having the correct contract form when they're doing home improvement contracts. The final bill I'd like to cover is SB 865. This bill makes several changes to the rules governing excavation. It refers to the Dig Safe Act of 2016, changes the name of some of the entities at the state level that govern or regulate excavations. It requires the use of specified mapping technology to regulate and notify with regard to excavations. And it requires the excavator to notify the regional notification centers within 48 hours of discovering or causing any damage to any underground facilities. It also updates some of the enforcement responsibilities of what they're referring to as the Dig Safe Board, including the option to require that violators take a safety education course in lieu of paying a fine. Kind of reminds us of the speeding violations, the Department of Motor Vehicles. You can take a safety class, a driving safety class, in lieu of paying a fine. Well, this is kind of the same thing. It now allows the Dig Safe Board to have violators take an education course instead of paying a fine. So that concludes my comments with regard to both COVID-19 and licensing rules changes. If you have any questions at the end of the overall presentation, please send them in and I will do my best to answer any questions you might have. Thank you. And now I would like to introduce my partner, Craig Tristao, who will cover the next topics.
Good morning. My name's Craig. I will be covering public works contracts and housing and residential contracts and changes to those two areas going into effect in 2021. We'll first go over public works contracts. We essentially had 4 bills this year in regards to public works contracts, and they all tended to apply to prevailing wages. The first bill, AB 2231, goes into effect in July 1st, 2021. And this bill enacts a safe harbor by defining what is meant by de minimis. Existing law, any project that was funded in part or in whole by a public agency would not have to comply with prevailing wage requirements if the amount of the public funding was de minimis. What AB 2231 does is actually define what is now meant by de minimis. And it does so in a way that's not very favorable to contractors. It requires two elements. You can be de minimis and under the safe harbor provision if your project receives less than $600,000 in public funds or less than 2% of the total project cost. With construction projects today, $600,000 may seem like a lot. However, a well for a public municipality is going to cost more than $600,000, even if it's less than 800 feet. The law also applies to single housing residential projects if the public subsidy is now less than 2% of the total project cost. So essentially what AB 2231 does is eliminates the de minimis requirement being a gray area that contractors could work with in arguing whether or not they had to pay a prevailing wage for their specific subcontract area, and concretely defines it with a bright line test. If the project is receiving less than $600,000 and if it's less than 2% of the total project, then you will be allowed to be safe harbored from the prevailing wage requirements. The next bill is 2311. 2311 requires public entities to include in their contracts a notice that the project is subject to skilled and trained workforce requirements. So essentially, if you have a job that requires a prevailing wage on your bid documents, your contract documents, and other documents that you're issuing to subcontractors, the law will now require you to include on that a notice that is a prevailing wage project. Now, the notice has no teeth. If you forget to include that notice, your subcontractor still can't try to argue that they're not subject to prevailing wages because the law does not allow that exemption. It still holds that prevailing wages are required regardless of whether or not your notice and bid documents provide notice to the subcontractor that it's prevailing wage job. So its purpose is essentially just to ensure that notice is given, but it doesn't provide any safe harbor for any subcontractors who aren't provided specific notice. Our next bill is AB 2765. And this one pertains to conduit bonds. Essentially, when a private entity receives government funding via the public entity issuing bonds and then repaying the bondholders, provided that the bond is for a public purpose. What this bill does is specifically for construction work done for private charter schools. If the project is paid in whole or in part with proceeds from a conduit revenue bond after the first of this year, it'll be required to use prevailing wages for the construction work. It's unknown how 2765 will interact with 2311. This says in whole or in part, whereas 2311 was providing a safe harbor for $600,000 or less than 2%. This bill doesn't indicate whether or not the safe harbor provisions applies, but our understanding is that it would, given that the safe harbor provision provides generally to public works contracts. The next bill, SB 588, provides for contracts entered into at the beginning of this year to withhold $10,000 or the final payment upon request for certification that amounts were paid to disabled veterans in accordance with prevailing wages. It doesn't specify any deadline except for 10 days after, or 15 to 35 days after you receive the notice. And if you fail to provide certifications, it's considered as forfeiting the $10,000 or final payment owed to the prime contractor. So that penalty is limited to the lesser of $10,000 or the final payment. Next, we'll be discussing housing and residential changes. And there was very little activity last year on this. There's only 2 bills that came into effect. AB 1561 pertains to entitlements. So when you go to the Planning and Zoning Board and you obtain an entitlement for construction work, that's usually good for only a set period of time. Due to COVID and the pandemic, they've extended that time frame for when you can effectuate your housing entitlement for your development for 18 months. So if you had it on March 4th, 2020, it's now good until December 31st, 2021. You'd have an effective 18-month period. AB 168. We developed in California a streamlining process because of our housing issues. Unfortunately, given the way our state works, now that we've got a streamlined process, we're now going to add additional requirements onto that streamlined process to make it more difficult for you. What this does is it requires that any development provide or allow in the streamlined process interact with a Native American to ensure that no cultural resources are being inhibited by the project. Typically, counties have tribes and tribal representatives who will provide these consulting services for a project, but that typically applied to larger products and not the streamlined project line. Well, I won't say unfortunately, but this is the beginning of an expansion of additional conditions on that streamlined process. So now, in addition to the requirements for a streamlined process, you will now have to comply with consulting with a Native American to ensure that you're not impacting cultural resources. Next, I'd like to return the stage to a Darryl Horowitt, who will be discussing wage and hour laws.
Thanks, Craig. I'm glad that the state of California is consistently trying to streamline the process by making more regulations. Truly a bureaucratic scenario that would make the people who wrote the Hitchhiker's Guide to the Galaxy happy. The first, there are several wage and hour laws, and I'm not going to deal with the COVID-related wage and hour laws that were enacted last year, such as that were covered by the CARES Act. If you go to our website at ch-law.com, you will find that last year we were busy providing you with information on new laws that affected businesses regarding the CARES Act, including the PPP. And we will be having another article coming out shortly that will assist you in the second round of PPP financing that was just approved at the end of last year. And so I'm just going to talk about some of the wage and hour laws that will affect you. Unless somebody was sleeping under a rock within the last year or so, you may not have heard of Dynamex if you were sleeping under a rock, but Dynamex Operations West versus Superior Court came out in 2018 and shook the employment community because the California Supreme Court determined in that case what some plaintiff labor attorneys were arguing, which is that everybody should be deemed an employee and nobody can be deemed an independent contractor except in certain limited instances. And what Dynamex determined in that case is that California will not follow what's called the Borello test. Instead, California, for the most part, is going to follow the ABC test. And there are three elements of the ABC test that are on the next slide. The first is that the worker is free from control and direction from the hiring entity. Well, every independent contractor normally would be free and independent, meaning I'm going to tell you, here's what I want you to do. You're on your own to figure out how to do it and get me the results. Number three, I'm going to take these out of order. Number three is the worker is normally engaged in an independently established trade. In other words, are they doing something that most people would be construed as independent contractors already? And for a lot of independent contractors, they were. They wanted to work on their own. They didn't want to be hobbled by having classification as an employee. Because if you are an employee of a company, you have certain duties of loyalty that come with that are statutory under the labor code, and they wanted to be free from those. They wanted to be able to compete against the company they work for. That's how the gig economy of Uber and Lyft and all the other companies that have come out after that were created because they wanted that flexibility. But then the B of the ABC test said that the worker performance work outside that performs work that is outside the usual course of the hiring entity's business. So if I'm a construction company and I have a worker, or let's say I'm doing finished carpentry and I have somebody I want to hire as an independent contractor who works finished contracting for me and about 10 other companies, that part of the ABC test says I can't hire you as an independent contractor because you're doing the same type of work that our company does. So that really threw people for a loop. What this did, though, the AB 2257, is it kind of freed up and created some exceptions to Dynamex and the ABC, because what was happening is once Dynamex came out, everybody was wondering, am I an independent contractor or am I not? Let's say that I'm a construction manager and I work independently. I don't work for any construction company, but an owner wants to hire me, does that mean I'm going to be an employer for an employee of the owner? Or if I work for a construction company assisting in estimation, and I do that for other companies, am I going to be considered an employee? So it came out with some exceptions, which don't really help the construction community, but do give some guidance. The biggest exception that applies to construction is business to business. It's for once, the legislature used common sense. It says if you already have a business and you're a corporation and you're working as a corporation and you provide management skills to contractors, they can hire you. That's a business to business exception. Also, a single engagement business to business company would be exempted. A referral agency, if you have an employee leasing company that refers the employees to, or actually hires the employees, those employees are actually not independent contractors to you. They're employees of the employee leasing company. But a referral agency for some businesses, they'll refer people out to you as independent. Then they helped by saying, well, professional services are. And then that helped until they decided what the professional services were. And it's actually those involved in the entertainment industry or in journalism primarily. Content contributors, advisors, producers. They did exempt home inspectors, which is fine, but they have their own company anyway. Performers, it's good to know if you want to bring a performer out to your job site, that person's going to be accepted. You don't have to put them on the payroll. And the same thing, manufactured, I don't know why they threw this in, but manufactured housing salespeople are going to be independent contractors and umpires. What's good about this, though, is in terms of the exceptions, is that in some instances, the legislature, recognizing that our public authorities, such as DAs and city attorneys and county counsel's office, are already overburdened, have given private attorneys the chance to sue on behalf of the state in what's called a private attorney general's action. In this instance, though, and so for wage and hour violations or wage statement violations, things like that, they can sue. In this instance, AB 2257 limited enforcement to the DAs. And for those who aren't aware of it, the Attorney General of California generally has the authority to enforce any laws. The DA of a county does, but also a county council, a city attorney in a city of over 750,000 people also has that authority. So we have at least 4 cities in California where the city attorneys have a lot of power to enforce some of these rules. And if you're working in one of those jurisdictions, just be aware of that. For those who aren't aware, also, there are some instances where the Borrello test, and Borrello is actually from S.G. Borrello and Sons versus the Department of Industrial Relations, and that was a multi-part test. And for those who are older, like me, what used to happen, and I'm saying 15, 20 years ago, if you had an employee or somebody you wanted to bring on, but wanted to bring on as an independent contractor, you would often talk to your accountant or an attorney to figure out if they're independent contractors, because the IRS looked into, had factors which are similar to Borrello as far as whether they're independent contractor. Now you look to the ABC test and the exceptions to that rule. Going to move on to AB 1947, which is the next slide. Employees who believed that they were fired and wanted to be a whistleblower and believed that they had been discriminated against had, under previous laws, 6 months to complain about their discrimination and to bring action. They can file a complaint with the Department of Labor Standards Enforcement. This law realized that COVID, it really isn't a COVID law, but it is. It extended that time by another 6 months. That people have 1 year. They also added another provision, which is similar to other consumer laws, which is they provided that the prevailing plaintiff in a whistleblower action, or somebody who believes they've been discriminatorily discharged, is entitled to attorney's fees. prevailing defendants are not entitled to receive fees, even if they can show that the action was brought in bad faith. There's no exceptions. I'm aware that of only one other law. There are others, I'm sure, out there. But I know that under California's Song-Beverly Consumer Warranty Act, the lemon law, only the prevailing plaintiff is entitled to recover fees. And I also noticed that that has brought a whole category of lawyers who sue over the most minor problem in cars. You're going to be seeing an uptick in litigation because now there's no downside. Anybody can file suit. You may still have rights to pursue the employee for malicious prosecution or for sanctions. There's nothing to say that you can't get sanctions against an employee, but since most courts are loath to award sanctions, it's just going to be harder to get them. So, but you should keep that in mind when you have somebody complaining. And also, don't necessarily, if you're an employer, don't necessarily just slough off what somebody's telling you when they believe they've been discriminated against or that there are wage and hour violations, because this law now extends the time, but now it makes you an easier target. But more importantly, sometimes when we read the cases that have come out from employees who complained about certain activities, and the employer sloughs them off, ignoring one employee over a favorite employee within the company without doing an independent investigation, that often comes back to bite those companies in the rear. And we urge you to talk to, if you have a question about a particular employee's complaint, you may want to have an independent investigation. We can help you contact somebody who can do that independent investigation and do it to help protect your company. Let's move on to the next slide, which is on leaves of absence. California, well, the United States as a whole is one of the few countries that does not provide employees an automatic family leave. We're behind the rest of the world. Other countries have paid leave. They also pay more in taxes for that benefit, but most other countries, especially in Europe, have paid leave for up to 6 weeks just for vacations for people. In the US, it's really up to each employer, except in California. The government's going to help you with that with the California Family Rights Act. Before the California Federal Family and Medical Leave Act, and California had its own version for 50 or more employees. So it used to be that if you're a pretty large company with 50 or more employees, you're required to give them leave up to 12 weeks for a new baby, to help care for a sick parent or grandparent or sick family member. That is now reduced. The law now is that if you are 5 employees or more, you now have that requirement. I know as a law firm, and we were managing at one time, and Dave can weigh in on this. We wanted to stay under 50 employees. That was one of our goals. We didn't necessarily, we did provide our employees with leave, but we didn't want the government to mandate it for us. Now it's mandated for everybody with 5 or more employees. And remember, you can't now try and claim that everybody else is an independent contractor. They're still employees. And if we go to the next slide, let's talk about what employees are eligible for leave. So that's all that's needed for them to be eligible is they have to be with your company for at least a year. Unless your manual provides otherwise, they have to work for the company at least 1,250 hours in the past 12 months, which is, I haven't calculated whether that's 30 hours a week or more, but it sounds close to that. And they have to be on a work site. And it says that it has 50 or more employees within 75 miles of that work site. But really now it's just 5 employees. What this does is just opens up 12 weeks of unpaid job protected leave, but also to the extent that the employees have benefits, including health care, the employer is required to pay the health care during the time that the employee is on leave. So Some of the reasons that you can take a leave, qualifying exigency, includes being called to active duty by the armed services, caring for a parent, caring for a grandparent, caring for a child, a new baby. It also allows stacking of employees. It used to be that before that if a husband and wife or two spouses worked at the same company, that they would be entitled to a total of 12 weeks. Now they can stack them. Each person can take 12 weeks off and stack them. So if you're an employee, it's much better for you now. You're also now able to care for a sibling. For those of you who have a brother or sister that you love enough that if they get sick, you're going to want to help them. This is actually a benefit that wasn't there before. We have a lot of family, as we have an aging population, we have more people who need to take time off to take care of ill family members, and this is an addition to that. This is not the hardest law to follow. It's not the easiest law, but what it does require is for those employers out there who have not yet updated their employment manuals, we urge you to consider updating your employment manuals. Let's go to the next slide. Employment manuals to make sure that the employees are aware of this. This is one of those benefits that are going to be on the poster that you have to post and probably should be included in your employee manuals. The next topic we're going to be talking about is pay data. There's not a whole lot to talk about there. There's SB 973. Any private employer with more than 100 or more employees, again, stay at 99 if you can, is now going to be required to file an employer information report under federal law, which will submit pay data to the Department of Fair Housing and Employment. You're now going to have to just provide information regarding the employee's race, ethnicity, and gender and job categories before March 31, 2021. The DFEH has enforcement along with the Federal Department of Labor, the EEOC. And you can expect that if the DFEH believes that there's a violator, they're on it. Dave can probably talk to how aggressive the DFEH can be at certain times. Anyway, thanks, Joe. Have safe travels today. But it is out there. So with that, I am done with my section. We're now going to pass this back to Craig to talk about CEQA.
Welcome back, everyone. CEQA, or California's Environmental Quality Act, requires projects funded by the government or that require any approval by a government entity to analyze the project to determine whether or not it will have a significant environmental effect, albeit either water pollution, air pollution, noise pollution. In some parts of the states, even blocking somebody's view of the ocean could be considered environmental impact. This year, with respect to construction in CEQA, there were only 2 articles of legislation, both of which their goal is to streamline construction projects, specifically construction projects related to water quality and transportation. With respect to water infrastructure, we have SB 974. SB 974 works in conjunction with the Federal Safe Drinking Water Act. These bills arrived from the drought in the Midwest, not just California, significant drought in the Midwest, and how that has impacted drinking water quality standards and drinking water supplies. In the East Central Valley around Porterville, we have areas where, due to the drought, their water table has declined. And unfortunately, they can't pay for public municipal water systems. They are small, disadvantaged communities, small meaning less than 10,000 people, disadvantaged meaning they don't have the economic ability to sell bonds and repay them to fund a public water project. The Safe Drinking Water Act was expanded in 2016 following the drought or in response to it to provide grants to these communities so that they could use the funds to improve or increase or actually implement safe drinking water supplies, wells. A problem that they ran into in California is that they would provide funds. However, the Environmental Quality Act would interfere with how quickly these water infrastructure systems can be implemented in certain areas. So SB 974 exempts specific water projects, those that have to do with small disadvantaged communities, from having to comply with CEQA, where the system to be implemented will improve the water system's water quality, water supply, or water reliability. So in sense, it's essentially a carve out so that smaller jurisdictions can take advantage of federal funds from the Safe Drinking and Water Act and other grants within the state and actually implement those programs without having the extra burden of cost and the extra burden of time in complying with CEQA. Going on to SB 288, this bill seeks to do a similar thing with respect to public transportation. A source of air quality pollution in California and elsewhere is our private transportation system on public roadways. One way to combat air pollution, aside from electric vehicles, is to increase public buses and public light rail services throughout the state. Unfortunately, California Environmental Quality Act has interfered with those projects as well. If you want bus rapid transit, the buses have to meet certain air quality standards. Light rail can impact endangered species and other things. What this does, SB 288, is exempt from those requirements of CEQA in its analysis. Those projects that are to increase bus transit, the use of buses, or light rail services on public right-of-ways, specifically highways. The goal is to increase high occupancy vehicle lane use. And by that, they mean lanes that are high volume and move quickly so that air quality is not impacted by the flow of traffic. Now, unlike the water exemption, the rapid transit exemption still has certain requirements. For any project that will be over $100,000, the public agency must still have 3 noticed hearings where it will receive questions and comments from the public about the project. It doesn't have to actually do anything in response to those public comments or questions, aside from respond to them. However, it must have these meetings, and they must be spaced out over several months, about 3 to 6, depending on the size. Also, you must conduct a racial equity analysis. And by that, they want to make sure that the funds are being used in communities of people of color, and in addition to disadvantaged communities. There's significant overlap between the two. However, this bill aims to increase public transport in areas where there is a racial minorities. This is an interesting bill in that it also goes beyond when the project has actually been implemented. During the scope of construction of these transit projects, the state is requiring ongoing meetings, at least 2 noticed meetings annually while the project is being constructed. The purpose of these meetings is speculative. They're being required mainly so that people can voice their concerns and questions about the project and how it's going. However, nothing has to come from those meetings. People can comment, people can be against the project, complain about it. However, there's no response required, and the project can just continue. So it's a bit perplexing as to why those onerous requirements of public meetings, notice requirements, and time dedicated to addressing public concerns is being implemented when there's no teeth behind it. Like the drought, another problem that California has been experiencing is wildfires. The past year, there have been several wildfires, including 9 out of the 10 largest wildfires that have been recorded in California. In response to that, California is enacting 2 bills, AB 3074 and AB 3164. AB 3074 applies to wildfire risks, requires defensible space, and ember-resistant zones. Essentially, this bill requires local agencies that have jurisdiction over property that have conditions that are subject to wildfires. They can require defensible space, which is areas where fire does not have fuel to progress on to either reach the home or go onto other property lots, and develop funding mechanisms to provide funds for the Department of Forestry and Fire Protection to implement and enforce this legislation. The final bill, AB 3176, is similar in that it applies to wildland urban interference wildfire risks. They want, for new projects and rebuilding, for the state and the local agencies to take into consideration the potential for urban interference with the wildlife in general, and two, specifically, whether or not that development and urbanization of a wild area can result in increased fires. That's essentially it, and it's essentially analysis that arguably should be covered under CEQA. However, based on recent events, it appears that CEQA didn't cover that area effectively. So in order to have these things taken into account, it's buttressed by AB 3164. It has to analyze those risks and account for them in project developments. That is actually the last. There are only 2 laws with respect to wildfires. That concludes my segment. I'll return it to Darryl to finish up.
Thank you. Before we get into questions and answers, and it's not on our slides, and I thought I would give those who are online, or those who may be listening later, an update on what's happening with the court systems. And it's not new laws. It's just you should be aware of the continuing reality of the COVID's impact. And we have discussed this in prior writings on our website that you can look at. But in California courts, all up and down the state have been impacted by COVID. Some with more resources are able to have trials. Some with less resources do not. For those who are considering litigation to enforce your rights, remind you that regardless of whether the courts are moving cases quickly or slowly, your right to record a mechanics lien or a stop notice claim and then to file a lawsuit have not changed. The time within which you can bring a claim may not have been expanded by the emergency legislation that Governor Newsom enacted at the very beginning, where he was extending the statutes of limitations because those ran out in September, and I don't believe that they've been extended further. So I urge you to remember that there are still time limits on any claims that you may have to recover what's owed to you. In addition, as we move on, the federal courts are continue to be in business, but because they are impacted by fewer judges that were confirmed, they're still very impacted. In Fresno, we have only one federal judge, and he, Judge Rhodes, is actually waiting to move permanently back to Sacramento, where he's going to be sitting there. We had a nominee, Dirk Palutzian, had been nominated by President Trump and supported by the local bar association, I believe, quite strongly. But due to politics, his nomination never went through. There was another judge in Sacramento. I think it was Llewellyn. He also was nominated. He was considered a very safe bet. He was not acted on, and I understand he was going to take Judge Drode's place, with Dirk Paluzzi taking Judge O'Neill's place. So right now we have no help. For those in the state courts, some court trials are getting out. Some court trials are being continued. Almost everything is being continued because California has a statutory scheme where civil trials are at the very bottom of the list of priorities. At the top are criminal trials because people have a right to a speedy trial. And then juveniles have a right to a speedy trial, and probate matters have a right to be heard, and family law matters have a right to be heard. And the civil trials for people over 70 or otherwise very sick and need to get a trial in before they pass away, they have priority at the very end, are civil trials. And because some of the criminal trials are being delayed because they cannot have in-person trials, when they are going to get back on now that Governor Newsom has restricted have lifted some of the restrictions, what we're going to be finding is the judges who would normally do civil trials are going to have to help out on the criminal trials in most counties. So just be aware of that. Just be patient. I will tell you that also, and Dave and Craig can chime in, they've actually participated in numerous video conference arbitrations that actually work out very well. The alternative dispute resolution community has adopted video conferencing as an effective way to resolve disputes. So if you have one, we are still settling them at a very high clip, just like if court was in session. We have several qualified mediators who are still in the community and helping out. But they're also conducting arbitrations by video. And Dave, why don't you have any comments about how those are going, and talking to contractors about many of whom have an obligation to arbitrate or mediate before they litigate, and how that's going?
Yeah, arbitration by video is effective as long as the attorneys and parties and arbitrator prepare in advance. And the reason that's important is because there are, technical challenges with using video format in terms of witnesses who may be in remote locations and may not have reliable internet service. Also, using video format, presenting evidence in the form of documents can sometimes be a challenge, particularly as you all know, in construction cases, there are oftentimes thousands of pages of documents, and having those in a format that can be easily uploaded and used in a video arbitration can be a bit of a challenge. So it requires a lot of advanced planning and consideration of those challenges, and understanding between the lawyers and the arbitrator as to what's going to be allowed or not allowed in terms of presentation of testimony and documents. So as long as that preparation takes place and everybody's on the same page, I have found that video arbitrations are just as effective as doing it in court. But if you don't do that preparation in advance, the arbitration proceedings can really be challenging.
If we have questions, we can answer them. If not, please just send an email to any of us, and we'll make sure to get you the answers that you need. Then if not, I'd like to thank everybody for attending today. Can we go to the next slide? I want you to note that wherever in California you have a need, we can help. Coleman and Horowitt has offices throughout California. We service Northern California from Fresno and Sonora, regularly handling cases in the Bay Area and the Central Coast. We also have offices in Visalia, Bakersfield, and Sonora, where we cover the Central Valley as well. In Los Angeles and Newport Beach, we have offices for meeting with clients, as well as attorneys who are handling down there. We cover also as far south as San Diego, and we do also cover the Inland Empire. if you have a need, we can probably cover, excuse me, bedtime for the hiccups. And if we cannot help you, we will make sure that we can find somebody who can. And with that, unless Dave or Craig have anything to add, we'd like to thank you for attending and remind you, or not remind you, but let you know that our next webinar will be on February 25th. It'll be on practical estate planning. It'll be at 9 to 10:30 a.m. And then we will also be having a webinar on effective collection techniques on March 18th at the same 9 to 10:30 a.m. If you have suggestions for what you'd like to hear about or read about, please let us know. You don't just have to have questions. We look forward to seeing you in the future. Thank you.